and welcome to a fresh episode of Legal Wrangle, where we will be presenting before you the latest updates extracted from the recent judicial pronouncements in the field of indirect taxation and sales tax. In today's episode, we will be covering decisions pertaining to customs, central excise, service tax and sales tax. Let us proceed with the details of our first case.
This writ petition was filed by an association of Indian tour operators engaged in the business of arranging tours for foreign tourists visiting India and some neighbouring countries. The petitioners claimed to have forged contracts with the foreign clients either directly or through foreign tour operators, and which were generally made via phone calls or emails. The bookings were confirmed generally in writing, stating the cost and other terms and conditions. The petitioners made all arrangements for the foreign tourists, including hotel accommodation, transportation by all modes such as rail, tourist buses, monuments, visits, including entrance tickets, entertainment, food, and restaurant bookings, etc. The petitioners organized package tours, including a bouquet of services. It was stated that the foreign tourists or the foreign tour operators made the entire payment for the package tour in convertible foreign exchange through bank transfer or bank draft or credit card payment.
Prior to insertion of Section 6A of the Finance Act 1994 with effect from 1st July 2012, tour operator services provided to foreign tourists were treated as export of services and exempted from the levy of service tax. The invoices raised after 1st July 2012 revealed that service tax at the rate 3.09% was charged on the cost of services provided by the Indian tour operators to foreign tourists. With the introduction of the GST regime with effect from 1st July 2017, the provisions of the earlier Finance Act 1994 and the rules thereunder stand repealed. Hence, the petitioners were concerned with the question of payment of service tax by Indian tour operators in respect of the services provided by them to foreign tourists during the period between 1st July 2012 to 1st July 2017.
Rule 6A subclause 1 creates two problems for the Indian tour operator organizing tours for foreign services. While clauses A, B and C are satisfied inasmuch as the tour operator is located in India, the recipient is located outside India and the service is not included in the negative list under Section 66D of the Finance Act, Clause D may not be satisfied where the service provided is a composite one. That is, the place of provision of a part of the service is inside India and the remaining part is outside India. Thus, Clause D is satisfied, if at all, only in part. Moreover, the second problem arising is that such service provided outside India cannot be made amenable to service tax, since it is not a service rendered in the taxable territory.
Further, Subrule 2 of Rule 6A states that the government may grant rebate of service tax or duty paid input services or inputs where there is an export of services. This presupposes that such provision of service outside India is in fact amenable to service tax. However, as already noticed, the entire Chapter 5 of Finance Act applies only to taxable services and those which are provided in the taxable territory.
Rule 6A is a piece of delegated legislation. It is a rule made by the central government in exercise of the powers under Section 94 Clause 1 read with Section 94 Clause 2 subclause F of the Finance Act, which bestows to the government with the power to make provisions for determining export of taxable services. Section 94 Clause 2 subclause F empowers the central government to make rules for determining when export of taxable services can be said to take place. It does not empower the central government to determine whether there can be export of non-taxable services, that is, services provided outside the taxable territory. Moreover, it does not empower the central government to make rules levying or making amenable the provision of certain services to service tax.
Section 94(2) HHH also permits making rules regarding the date for determination of rate of service tax and place of provision of taxable service. It does not provide for making rules on determination of taxability of a service. Although subjecting certain types of service to tax is an essential legislative function, however, Since the Finance Act envisages Chapter 5 applying only to taxable services, bringing non-taxable services within the ambit of service tax is impermissible. The whole of Chapter 5 applies only to taxable services. If by means of rules under Section 94, what is not taxable under the Finance Act cannot be made taxable. Similarly, they cannot be made taxable even by rules under Section 93B.
The words any other service occurring in Section 93B is subject to Section 64(3) of the Finance Act that precedes it. It cannot expand the scope of Chapter 5 itself, as it is already established. This is an essential legislative function which cannot be delegated to the central government. Rule 6A, Clause 1, Subclause D, treats even services provided outside the taxable territory, that is, where the place of provision of service is outside India, as an export of taxable service. Such service, by virtue of Section 66B, read with Section 65, Clause 51 and 52, read with Section 64, Clause 1 and 3 of the Finance Act, is not amenable to service tax in the first place. Therefore, such service is not taxable service, and so Rule 6A is ultra vires of the Finance Act.
Since tour operator services are intermediary services, and under Rule 9 of the Place of Provision of Services Rules 2012, the place of provision of service is the location of the service provider. The package tour services provided by an Indian tour operator to a foreign tourist, considering that some part of it is provided outside India, would be treated as service provided in India. Consequently, no Indian tour operator could expect the service rendered to a foreign tourist to be considered as an export of service under Rule 6A, as he will never be able to meet the requirement of Rule 6A 1D of the Service Tax Rules. Thus, a combination of Rule 6A of the rules and Rule 9 of the Place of Provision of Service Rules 2012, something which is not taxable under the Finance Act is sought to be brought to tax. Now let's go to Anuj for the details of our next case.
The facts of this case are that a container with imported goods was bought by the shipping line Messrs. ADL under the cover of a bill of lading, which was in the name of the appellant as the consignee, based on certain intelligence that the said container contained undeclared and counterfeit items. The customs authorities conducted a physical examination. Later, a show cause notice was issued for alleged misdeclaration of goods, following which goods worth about Rs 1.45 crores were confiscated with an imposition of redemption fine. Besides, the confiscation of supposedly counterfeit goods valued at about Rs 82 lakhs was done, along with an imposition of penalty of Rs 50 lakhs under Section 112A of the Customs Act.
Before the tribunal, the appellant claimed to be neither owner nor the importer of the goods. It also claimed to have not filed any bills of entry and so sought to be absolved of charges of misdeclaration. The appellant claimed to have not placed any order for the imported consignment and argued that it could not be penalized for a consignment which was not imported by it. In light of the same, the appellants challenged the penalty too.
The bench examined the meaning and scope of the term importer as defined in the Act. It includes any owner or any person holding himself out to be the importer. The bench held that these details were to be established by factual inquiry, and that when the appellant did not himself hold out to be the importer of such goods, then it was for the revenue to categorically establish that the appellant was indeed the owner of the goods. The bench also held that barring the bill of lading, which itself was disputed as a mistaken transaction by the shipper, there was no other evidence on record to hold that the appellant was the importer of the goods or the person behind the importation of such goods. Admittedly, there was no evidence that the appellant received any invoice, packing list, or remitted any money towards the impugned goods. In fact, there was correspondence to show that the appellants protested with the supplier on the receipt of consignment in his name. The bench observed that without commenting on the genuineness of such correspondences, it could still be concluded that the appellants did not fall within the statutory scope of importer under Section 2, Clause 26 of the Act.
The bench noted that no bill of entry had been filed in the present case, and it also noted that from the bill of lading, the adjudicating authority had concluded the description of goods in the bill of lading could have led to misdeclaration in the bill of entry. The bench observed that such presumptive reasoning was not provided for in law. The bench asserted that the misdeclaration could be alleged based upon only one statutory document in respect of import, the bill of entry under section 46. The bench finally clarified that the bill of lading was not a document of declaration of contents of imported items statutorily filed by the importer with the customs authorities for clearance of goods. In other words, the bill of lading is not an assessing document for customs authorities and could not supplant a bill of entry. Thus, the impugned order imposing duty demand with penalty was set aside. Now let's go to Anuj for details of the last case.
The SSE company manufactures and lays pipelines for water supply schemes. In pursuance of an agreement with the Public Health and Engineering Department of the state government, the SSE supplied pipes along with labor and services for laying down pipelines. Meanwhile, the state government released two notifications granting exemptions to works contract with retrospective effect and also exempting from tax all works contract relating to dams and canals. In execution of the projects, the SSE company laid down pipelines pertaining to the construction of a dam.
Subsequently, when the SSE claimed exemption from payment of tax, it was denied by the CTO on grounds that the pipes manufactured and supplied by the SSE fell within the definition of sale of goods and that the contract was divisible in nature. Thereby, 75% value of the contract was treated as consideration for sale of goods. Later, the appellate authority, the single bench, and the High Court of Rajasthan upheld such findings of the CTO, holding that the SSE was not entitled to claim exemption for supply of pipelines as such supply was termed as sale.
Later, the Apex Court held that by virtue of the 46th Amendment to the Constitution, a single and indivisible contract is now brought on par with a contract containing two separate agreements. It also reaffirmed the settled legal position that state governments had the power to levy sales tax on value of material in execution of works contract. It also stated that taxing the sale of goods element in a works contract was permissible even after the incorporation of the goods, provided that tax was imposed on the value of the goods at the time of incorporation and not on the transfer of immovable property.
Upon examining the agreement between the SSE and the state government, the court held that the authorities had found that manufacturing and supply of PSC pipes, jointing material specials, valves, anchor blocks, etc., did not fall within the scope of buildings, bridges, dams, roads, and canals. It also held that the agreement was clearly in two parts. Firstly, sale and supply of PSC pipes, jointing material specials, valves, anchor blocks, etc. And secondly, the remaining part being supply of labor and services. Thus, in view of findings of the authorities, the court held that element of sale of goods would apply to jointing material specials, valves, anchor blocks, etc. as well. Hence, the Apex Court upheld the findings of the High Court that sales tax was applicable on the supply of pipes by the SSE. Thank you for watching this episode of Legal Wrangle on indirect taxes. Please stay tuned to TIOL Tube for more videos on subjects pertaining to direct and indirect taxation, corporate law, and international law. Please feel free to share your feedback with us at editor@tiol.in. Thank you and have a good day.